Download Tarang online radio app from Google Play Store.
आप सुन रहे हैं तरंग डिवोशनल,
आध्यात्म से जुड़े।
Where do you see the international arbitration, whether for the domestic companies and for the international companies who are working in India? And I assume that arbitration is part and parcel of the business.
So India, I mean, one has to answer that question in the context of two issues in the background. India is a country where we have an overcrowded civil court system where courts have a problem of backlog, and getting commercial disputes decided very quickly is literally impossible. And yet, together with that, we have an environment where we are a country that is growing very fast. We want a vibrant and fertile commercial environment, and in that background, commercial arbitration and international commercial arbitration is a very strong requirement, not just something that we can aspire for, but it is something that we cannot do without. And it is a very strong requirement, and strengthening that regime is absolutely essential. And I think this conference is one of those efforts where professionals who practice in that area get together and exchange ideas as to how we can make this system more vibrant in our country. It has been a very interesting discussion today where, for a change, the overall assessment was not gloomy but very positive. There are a lot of developments in India, both by way of judicial intervention, or shall I say judicial non-intervention, and also at the government level, which we feel are positive developments and will give a huge impetus to the growth of arbitration and commercial arbitration, and then international commercial arbitration in India. But also there were suggestions about areas that perhaps have remained unnoticed and might still be problem areas, and it is important for professionals and policymakers to look at those issues for further fine-tuning the change, for making it a very vibrant arbitration-friendly jurisdiction. So overall, that I think is a very positive contribution of today's conference.
And also a law that was supposed to come into the parliament, now that the parliament is sine die, that has lapsed. We hope that in the next, when the next time parliament sits in May or thereabout, we'll have this positive thrust to the arbitration in India domestically and internationally.
Yes, I mean, while there are a lot of positive things in the proposed amendments, and we look forward to the legislature making an effort to improve and fine-tune the Arbitration Act as and when it is required. Today's discussion and deliberations during today's conference have also thrown up one or two grey areas where perhaps the amendment could be problematic, and we hope that a synopsis of today's deliberations would reach people who matter in terms of framing policy, and they would consider, because a lot of the input came not only from India's professionals, but professionals from other countries who do a lot of India-related commercial arbitration work. But yes, overall, I think I think that it is a good move on the part of the legislature and on the part of the government to look at amendments and improvements in the Arbitration Act and the arbitration regime as early as possible rather than leaving it for decades of problems to build over and pile up before they can have a look at the amendments again.
Would you like to stress or highlight few of the points that you feel that needs attention? Because I am sure our program is seen by the government and the other ministries, because more important is finance ministry and the law ministry, which have to have a major, they are the major player, or what we call they are major contributors.
So leaving aside the technical issues that were discussed today, I think one of the most simpler suggestions that has come forward, and I think that is something that perhaps needs to be considered very well, even if it were to be rejected or even if there was to be some resistance to it, is the suggestion that has come uniformly both from local professionals and from professionals abroad, that there should be some degree of flexibility in allowing lawyers to represent foreign clients. Shall I put it differently? For allowing foreign lawyers to choose their lawyers from their own of their own choice to come and represent them in a private arbitration forum in India. And the view that came from several quarters is that a certain degree of fresh air, of opening up and exchange of ideas amongst professionals, and it can be restricted only to foreign clients who want lawyers of their choice to come when they arbitrate in India. But a certain degree of flexibility and fresh air, we believe, will give an impetus to growth and competition. To that extent, a lot of contributors felt that contribution to that extent would be good for our system.
But I assume that what government is thinking is something on the lines that there may be a little bit of, I won't say arm twisting, if that comes into effect, that Indian lawyers working for foreign companies or foreign companies hiring Indian lawyers, there is a little bit of a gray area, or you call it a doubt, that it may backfire because the Indian judiciary also needs to grow. Is it something that you align, or you still fear that it has to open, that is the only way out?
I think it is definitely an area that requires discussion. And it is, the concern that you have just surfaced, there are several concerns of that nature which are valid concerns. But I think it is an area that deserves discussion, extensive discussion, and specifically in the context of international commercial arbitrations, where foreign parties are being invited or being encouraged to arbitrate in India because the dispute has an Indian element. I think in that limited context, this is a suggestion that needs to be thought through, because it is a voice that we kept hearing throughout the seminar today.
And also what you are saying is right. If you want to be a major player in international arbitration and you don't allow your lawyers to practice from one party or the other party, national party or domestic party or the international party, then you're not playing by the rules. And I think that will be an impediment what you are foreseeing.
So there is a certain degree of concern that comes from the Indian bar, which is a legitimate concern, because the expectation is that there should be parity in reciprocity, that there should be equal access to Indian lawyers in those jurisdictions from which we are allowing lawyers to come in, and perhaps that is an aspect that should again be considered, and that perhaps that should be one of the important tests that is kept in mind. But I think the overall issue is that in the context of private arbitrations of commercial disputes, even if they are of international nature between private parties, the flexibility to allow professionals across jurisdictions to have a say might perhaps contribute to the growth of a positive arbitration environment. But as I said, it is not these are the thoughts that came up during the course of discussions today. But this is a theme on which policymakers just need to take a considered decision, and it needs to be analyzed and thought through in the limited context of international commercial arbitration.
And I assume that what you're saying about the US and the London, New York, the London Center, Singapore, now Dubai, those countries also need to be talked about at the government level to see that our council could work there as well, as long as we allow them to come.
A lot of those jurisdictions have already allowed that much of flexibility for Indian lawyers. And I think the entire discussion or this entire discourse that you and I are having on this limited issue has to be seen in the context of a big concern that there is a lot of outflow of high value international commercial arbitration work from India to other jurisdictions, neighboring jurisdictions, just because that would give a foreign client the flexibility to get a counsel with whom that foreign client has been working for years together to deal with that dispute when it is in arbitration. And I think this entire issue, perhaps, because that is the suggestion that came from 2 or 3 very important contributors, it is a suggestion that needs to be considered.
And Datar Saab, I was talking to Datar Saab, and he also said that most of the foreign companies are more happy having their arbitration done in Singapore or Dubai for the friendly climate or the environment, a more open environment and more robust environment. And we don't have an ecosystem. We are in the process of building, and Singapore took 15 years to the position what they are today.
Yeah. So I think there is a lot to be learned from the Singapore experience, and there is a lot to be, I don't see. There is a lot of work that goes from India to Singapore, but then Singapore is not India is a huge country, and even if there is work going from India to Singapore, it's a very small part of the total arbitration work that we have here in this country. But I think to make India generally an arbitration-friendly nation and perceived to be a generally arbitration-friendly nation is important in order to not just for arbitration and arbitration professionals, but in order to sort of make this entire larger purpose of India being a vibrant commercial jurisdiction a reality.
Download Tarang online radio app from Google Play Store.
You are listening to Tarang Devotional Online Radio.